afternoon, ladies and gentlemen. We're very grateful for your time and attention today because we are here for a very serious matter. We're here because Mr. Miller unlocked a door, walked outside, pursued an unarmed man, and then committed an unjustified killing. Now, defense counsel has said that he's going to take a long time for his closing. He's already told the court that. And I guess it would take a long time to even attempt to justify to you what happened here. Defense counsel is going to focus on a lot of things that respectfully just don't matter. What matters was Mr. Miller's mindset at the time this happened and his actions. And I think now that you've heard all the evidence, his actions speak for themselves. What did we learn about Mr. Miller? Mr. Miller was in the military, and I'm not trying to diminish his service in any way. Very grateful to anyone that serves our country. But he was trained in the military that you don't just shoot someone once, maybe to scare them off. You shoot them until they're dead. You shoot them until they're dead. And you heard his own wife here, supposedly testifying on his behalf, but she said he gets angry. He even scares her sometimes. You heard his own wife say that. So what happened on the night that Mr. Quest unfortunately died? Mr. Miller hears an alarm go off. He goes down to his basement. He sees someone trying to get in. And that makes him angry. How dare someone be confused about what house they're at in the middle of the night and try to open his basement door? You know, Mr. Quest tried to open the door and then stopped. He walked away. This all could have been over. He walked away. But no, Mr. Miller was angry. How dare you try to get in my basement? I'm going to go. I'm going to unlock the door. I'm going to take off the security bar. I'm not going to wait for the police to get here, even though I know that they're on their way. Oh no, I have to pursue this man. It's only because he goes outside and pursues this man that this even happens. You don't have to be here. Mr. Miller is claiming that he was scared, but he created the situation himself. So he goes outside, tells the man, put your hands up. He does. There's no weapons in his hands. There's no one else out there. The man then approaches Mr. Miller. What does he do? He shoots him. And Mr. Miller told you that many of the shots were in his basement. Mr. Miller's here to testify on his own behalf. But you were the detective on the stand. He told you that he marked in this diagram where the locations of the bullets were. So he shoots the man says, ow. The man walks away. Again, this could be over. We might not have to be here. But no, Mr. Miller is angry. Shot you twice in my basement. You attempt to leave. 2 more shots. And then what? The man is walking away. What possible reasonable fear could Mr. Miller have at that time? He knows he's unarmed. He's walking away from him. The court is going to instruct you on the law, and the court is going to ask you to think about Mr. Miller's mindset. How could Mr. Miller possibly have been afraid at that point? No. At that point, Mr. Miller had only one thing: the intent to kill this man, just like he was trained to in the military. He had the intent that this man needed to die. So what happens? 2 more shots into the back of this unarmed man. And defense counsel is going to get up and try to explain to you that that's reasonable, that that's something a normal person would do. But you don't check your common sense at the door, ladies and gentlemen. And common sense says shooting an unarmed person in the back, you are intending to kill that person, especially in light of Mr. Miller's military training. So what else is defense trying to get you to believe in order to believe that this was justified? There's all this nonsense about his wife's ex-husband. But don't be fooled by that. That's a nice after-the-fact excuse, isn't it? Too bad for Mr. Miller. He told the detective on the night in question, on the night this happened, he told the detective, no, at the time I was shooting this man, I knew it wasn't her ex-husband. So they're really almost insulting your intelligence by asking you to believe that defense. Because you saw his testimony, I put it right up there on the screen. It didn't even enter his mind at the time. And the only thing really relevant here is what happened at the time. So, just to go through this with you, Mr. Miller's been charged with 4 things. The first one is first-degree murder. Again, the court is going to instruct you on this law. But to find Mr. Miller guilty of first-degree murder, which I respectfully think you should, you have to find that William Quest is dead, not in dispute. Find that the defendant killed him. Again, not in dispute. So the only thing in dispute is this third element. Did Mr. Miller act with specific intent to kill and with malice? I respectfully submit to you that when you choose to leave your home to pursue someone because you're angry at them, and that when you continue to shoot at someone until you know they're dead because you're shooting them in the back, you are acting with specific intent and with malice. I think that you should find Mr. Miller guilty of first-degree murder, but if you don't, he's charged with 2 other offenses. One, third-degree murder, has the same first 2 elements as first-degree murder, but you just have to determine that he acted with malice. Again, respectfully, I think he did. And then finally, voluntary manslaughter. For this one, you have to find that he acted with the intent to kill. And again, I respectfully think that he did. Now, Mr. Miller told you he had no other option, but I think we all know that he did obviously have another option. Stay in your home where you are safe and wait for the police to arrive. Mr. Miller said to you, yeah, Monday morning quarterbacking, maybe that's what I should have done. Even he knows that's what he should have done. But you know who doesn't get to Monday morning quarterback? William Quest. Because he is a young man, and his life was tragically cut short. Because this man got angry. He got angry. How dare you even attempt to come to my home? There's no Monday morning quarterback for Mr. Quest. The only thing that can happen to Mr. Quest now is that you serve justice in his name. And that's what I would ask you to do. Thank you.
Thank you.
On April 14th, year 2012, John Bartholomew Miller was awakened by a burglar alarm. He wasn't angry, he wasn't attacking, and he wasn't invading anyone's home. He got up and he went downstairs to protect those he loved, to serve the wife that he honored, and to defend the home that they had made. He was confronted by an alcohol-infused, 300-pound monster trying to get into the house where those he loved lived. John knew that without his family, his tomorrow was not worth waiting, and his yesterdays would not be worth remembering. Ladies and gentlemen of the jury, good afternoon. We are here because of the events of that evening, events that were put into place not because of the actions of John, but because of the actions of a person who refused to walk away. John on that particular night did as anyone would do. He went to protect, to serve, and defend his family. Now, this is his last opportunity to speak to you, to argue the facts of this case if it were. But I'm not going to argue. I'm going to attempt to discuss with you the inferences and the logic that flows from the evidence that you heard during the course of this case. We'd first like to say thank you, because that's something I believe you're entitled to. You gave up your Saturday. And everyone here appreciates that. Now, the judge will instruct you about the evidence. Two types. Direct, seen, felt, and heard, and experienced by those individuals that were there during this night that was created, not by them, but by the actions of an alcohol-infused, 300-pound invader who refused to walk away. You also heard circumstantial. Well, obviously, we're having technical difficulties, but circumstantial evidence. Think, come to a conclusion. Statistics, medical examiner, things of that sort. And when you look at that evidence, it all points to one thing, that on that particular night, John had no other choice. Now, every one of you, when you came in and when you agreed to be part of this program, to decide this case, you agreed to do it based on the evidence that you heard, to keep an open mind. And you promised that you would do that until the conclusion of the case when you decided. A promise, something that we all sitting in this room are counting on. A promise. We're going to request that you do that, hold you to that promise, and to decide this case based on what you observed. The judge is going to instruct you about the law. Reasonable doubt is a term that is very important here. Reasonable doubt that would cause a reasonably careful and sensible person to pause, hesitate in a matter of importance in his or her own personal affairs. Cause you to pause in a life or death decision. A decision that you can't go back and change. Oftentimes, and you may hear the description or suggestion that reasonable doubt is a thing like buying a house or getting married, purchasing a car. I would suggest to you, though, each one of those things, you can go back and change if you think, well, maybe didn't quite work out. No. For John today, your decision is a life or death decision. Not buying a house, not buying a car, but perhaps ending the life of a relative. Because once you make that decision, you can't go back and bring it back. And that's a decision that you're going to render today for that man sitting in the courtroom. The question that you have to ask as you ponder this is, did they give you enough evidence to end that life? Let me repeat that. Did they give you enough evidence to take that life? And if they didn't, and you pause, they didn't do their job. And that man should go home. Let's talk about John Miller. John Bartholomew Miller went into the military back in the 60s, served in Vietnam. You heard from his mouth. It was a very different world back then. Protesters, calling soldiers names. They weren't respected. Butt of jokes, used as props, but he still went in and served honorably. He didn't live in a world where there were statues and parades. But in spite of that, he served his country. He did what was right back then, and he did what was right on that night in April 2012. Let's talk about the individual that invaded his home. 305 pounds, 0.28 BAC, 3 times the legal limit. What did you hear from the coroner? Robust, 5 inches taller. We know from the evidence, highly functional when intoxicated. Well, this is a guy driving around in a car, lit, half John's age, drove home. He's walking up and down stairs, walking around, and we know from their witness, he was functional enough to decide what house to go into when he first got home. So you have to ask yourself this question. If an hour or two earlier, he's drunk enough that he can do all of these things, he's not so drunk that he doesn't know what he's doing, he can drive home, he knows what house to go to. On the night in question, when he goes to John's house, do you think that it was just an accident? Or maybe, half naked, he had another motive. You heard about the threatening gestures. He knew what he was doing. He knew the effect that he wanted to have. And he got that effect when he threatened John, forcing him back into his house. This was a man who had choices, and he chose to take it to the next level. And that's why we're here. Entering John's home, refusing to retreat. These are all things that you need to take into account. Did they prove to you that what John did was inappropriate? Did they give you enough evidence to pull that through? Let's talk about the witness, Martin. Is there bias, animosity, anti-military, anti-veteran? Why was he so fixated on Quest? Watching him go out and use the restroom multiple times. You got to ask yourself that question. Does that suggest something else to you? Watching him in the middle of the night. You heard from this stand that he was well aware of the fact that Mr. Quest would drive his car drunk. But did you ever hear him say anything about reporting that to the police? Reporting that danger? Trying to stop that? You got to ask yourself that question. Why? Can you really rely on him? The medical examiner. Very, very, very important. He told you a lot of things. But he didn't tell you how far John was away when the shots were occurring. But he said only 2 of the shots were incapacitated. But what does he tell you? That .28, and because of that .28, he was a threat. Because of that .28, he was dangerous. But what else did he tell you? He confirms that John's condition with the triple bypass, that it was a surgery that was serious. Physical exertion is not recommended. He corroborates what this man just got up there and told you, that he couldn't fight on the night in question because he had a bad ticker. Their own witness corroborates that. Let's talk about what the police did, or better yet, didn't do. Why didn't they take any photos of this? Why were there no exact measurements? What did the detective say? Well, you know, didn't really give you much of a reason why. Why weren't clothes, things of that sort tested? Why was no complete testing done? You heard. Well, there was carpet. Did you test that? Oh, no. But what about the floor? Oh, no. This is a homicide scene. This is not a shoplifting case. A man's life is in jeopardy. And they couldn't take the time to do a little bit more to find out what happened. Rust adjustment. Talk about that gun, the weapon. You heard from the officer. Double action, single action. You saw the Ruger with the hammer on the back. The ballistics report, one weight. They didn't bother to test it in both conditions. Why? Why wasn't this done? What else didn't the police do here? Sounds like they made up their mind within a few minutes, and let's keep it moving. This man's life is in jeopardy. Are you going to take it away and pull the plug based on this? John Miller, look at the actions that night showing an innocent man. Wife called the police, allowed the police into his home, allowed them to recover whatever they wanted. Surrendered the weapon, went to the station, full statement. Multiple steps to avoid using deadly force. He didn't go out there guns a-blazing. He took the time. He did everything until he had no other choice. Acted when he had no other choice. And realistically, if you're in your house at 4:30 in the morning and you're between, the only thing protecting you is a glass door from a guy 300 pounds, and he's pulling on it, and you know that that door is not going to stop him, what are you going to do? Your mom, your dad, your wife, your girlfriend, your child is upstairs. They're depending on you to protect them. What are you going to do? John Miller, he legally purchased this weapon. This wasn't somebody who went out on a street corner and found the guy for a couple of bucks. Went through the process, bought it, still had the receipt some 11 years later. What does that say about him? License, went through the process of clearing a background check, showing his training, showing his familiarity. He gets a license in this Commonwealth. He's authorized by the state of Pennsylvania to carry that weapon anywhere he chooses because they saw his character. And on the night in question, when the police were coming, secured it. Didn't attempt to hide it, didn't attempt to get rid of it, didn't attempt to disappear. Does that sound guilty to you? And the question is again, is that enough for you to pull the plug? Murder? No. Where's the malice and where's the premeditation? Let's look at the absence of malice and premeditation that night. John didn't wake up, even better. He didn't go to bed that night thinking, I'm going to go kill somebody. Think about what he said. Set the alarm. Went to bed. Alarm goes off at 4:30 in the morning. And take a moment to think about 4:30 in the morning. If you get awakened, what are you thinking? He goes downstairs, deactivates it, returns to the bedroom to check on his wife, retrieves the weapon, instructs his wife to call the police, loads the weapon, but as he said, he didn't put one in the chamber. Why? Because he wasn't thinking he was going to kill someone. He was hoping at most he'd have to scare them. That's it. Walked to the point of the intrusion, turned on the lights, yelled, went to the door, told him to raise his hands, instructed the intruder to lay down, retreated as the intruder began to approach him, into the home, unable to re-secure the door. But as we've heard from multiple witnesses, this is a glass door. Even if he had, could it have stopped him? Continued to retreat, ordered the 300-pound intruder to stop, pointed the weapon, pulled the trigger, didn't fire. I'm sorry, no matter how intoxicated you are, when you are given the warning with a dry fire as it was described, what do you think that means? And if you don't intend to do harm to people in that location, what does a reasonable, normal person do? You get the hell out of there. And the fact that he didn't, what does that say about his intent in that house? Retreated until his back was against the wall, continuing to approach. And the smirk, what did he describe it? Like in a horror flick the killer gives you right before he starts a chopping. Think about that. At that point, he engaged. No other choice. And he fired until his family and loved ones were safe. He waited for the police, turned over the weapon, voluntarily went with them, gave a full statement, hiding nothing, and made no attempt to hide. What else could he have done that night? This is not murder. He didn't start it, didn't escalate it, didn't encourage it. He only responded to the 300-pound man in his house, half of his age, .28 BAC, invading his home, threatening his family, refusing to comply. In the middle of the night, what else could John have done? Justification. There are several questions that you will have to answer. And I want you to keep this in mind. From the reasonable person, did John believe that only deadly force would be adequate to stop the intruder who was in the process of invading his home? From the evidence that you presented here, you have the answer already. Did John reasonably believe that he was in immediate danger of death or serious bodily injury from that intruder? From the evidence that you received, you have that answer. Was that belief reasonable? At 4:30 in the morning, what are you going to do? What are you going to do? John did what he could. John did what he had to. And because of the fact that this individual wouldn't walk away, we are here today. Was that belief reasonable? Yes, it absolutely was. John is simply described by these two words, not guilty. These are the two words that only you can pronounce. I've talked a lot, and you guys have been for quite some time, so everyone's had a lot to say to you. But you know what? The time is going to come for you to speak, to say the words that only you can say, to say the words that will end this man's nightmare, and to say the words that will put him back with his family, to allow him to be the father to that little girl, to be the husband to that wife, to be the support system for that family. And those two words are not guilty.
Mr. Goodman, rebuttal from the council.
As I suspected, defense counsel got up here and said a lot of things. He tried to throw a lot at the wall and see what would stick. Why didn't the police measure the townhomes? And why was the neighbor looking out his window? It's funny. What he didn't tell you is why any of those things matter. It's because they don't matter. The only thing that matters is what Mr. Miller was thinking at the time this happened. Now, defense counsel called the victim here an invader who refused to retreat. I think that's ironic because we all know that that's exactly the opposite of how the evidence has come in this case. He didn't invade. Mr. Miller unlocked his door and pursued him. He didn't refuse to retreat. He was retreating, and Mr. Miller shot him in the back. Now, at the end of the day, all we have to do is prove to you that Mr. Miller acted with an intent to kill. Of course he acted with an intent to kill. You shoot until the target's dead, just like you learned in the army. But I guess defense counsel wants you to think Mr. Quest deserved to die because he had been drinking. They don't think that someone deserves to die because they've had a few drinks. Mr. Quest deserved to die because he was disoriented in the middle of the night and initially went to the wrong house. Do we want to live in a society where someone being confused and trying to open the wrong door is justification for murder? Is that really what we're saying? If someone becomes disoriented and confused, then they deserve to die? I don't think that that is the standard we want to have here. I don't think that this is the type of neighbor we would feel safe having. Mr. Miller acted with the intent to kill because he shot this man in the back. What else do we know? How else do we know that he wanted this man dead because he was angry? We know that because he shot him in the back. He was on the ground. It's not in dispute here that he was incapacitated. And he didn't go over and see if there was a chance at saving that man. We know that he had the intent to kill because after he's on the ground, he doesn't care. He doesn't say, maybe he's still breathing, maybe I should call an ambulance. No, his actions speak volumes. He doesn't go check on him. He goes back inside the house, puts his gun down. Those actions speak volumes. Those are the actions of a man that acted to kill. Those are the actions of a man that committed first-degree murder. That's why, again, respectfully ask that you go back and serve justice for William Quest and West family. Thank you.
Thank you, Ms. Robinson. Ladies and gentlemen of the jury, you are about to perform one of the most serious duties of citizenship. You are going to decide whether a fellow person, the defendant, is guilty of a crime charged by the Commonwealth of Pennsylvania. A fundamental principle in our system of criminal law is that the defendant is presumed to be innocent. The mere fact that he was arrested and is accused of a crime is not any evidence against him. The defendant is presumed innocent throughout the trial unless and until you conclude, based on careful and impartial consideration of the evidence, that the Commonwealth has proven him guilty beyond a reasonable doubt. It is not the defendant's burden to prove that he is not guilty. Instead, the Commonwealth has the burden of proving each and every element of the crime charged, and that the defendant is guilty of that crime beyond a reasonable doubt. The person accused of a crime is not required to present evidence or prove anything in his defense. If the Commonwealth's evidence fails to meet its burden, then your verdict must be not guilty. On the other hand, if the Commonwealth's evidence does prove beyond a reasonable doubt that the defendant is guilty, then your verdict should be guilty. Although the Commonwealth has the burden of proving that the defendant is guilty, this does not mean that the Commonwealth must prove its case beyond all doubt and to a mathematical certainty, nor must it demonstrate the complete impossibility of innocence. A reasonable doubt is a doubt that would cause a reasonably careful and sensible person to hesitate before acting upon a matter of importance in his or her own affairs. A reasonable doubt must fairly arise out of the evidence that was presented or out of the lack of evidence with respect to some element of the crime. A reasonable doubt must be a real doubt. It may not be an imagined one, nor may it be a doubt manufactured to avoid carrying out an unpleasant duty. The evidence in this case is of two types. On one hand, there is direct evidence, which is testimony by witnesses with personal knowledge, such as something he or she saw or heard himself or herself. The other type of evidence is circumstantial, which is testimony about facts that point to the existence of other facts that are in question. Whether or not circumstantial evidence is proof of the other facts in question depends in part on the application of common sense and your human experience. You should recognize that it is sometimes necessary to rely upon circumstantial evidence in criminal cases, particularly where the crime was committed in secret. In deciding whether or not to accept circumstantial evidence as proof of the facts in question, you must be satisfied, first, that the testimony of the witness is truthful and accurate, and second, that the existence of the facts the witness testifies to leads to the conclusion that the facts in question also happened. The speeches of counsel are not part of the evidence, and you should not consider them as such. However, in deciding the case, you should carefully consider the evidence in light of the various reasons and arguments each lawyer presented. You are not required to accept the arguments. It is for you and you alone to decide the case based on the evidence as it was presented from the witness stand and in accordance with the instructions I am giving you now. You should not decide this case on the basis of which side presented the greater number of witnesses or the greater amount of evidence. Instead, you should decide which witnesses to believe and which evidence to accept on the basis of whether or not the testimony or evidence is believable. In deciding which of several witnesses to believe, it is proper for you to consider whether or not the testimony of each witness is supported by other evidence in the case. However, you should recognize that it is entirely possible for a single witness to give truthful and accurate testimony, and that his or her testimony may be believed, even though a greater number of witnesses of apparently equal reliability contradicted him or her. The question for you to decide, based on all considerations I am discussing with you, is not which side produced the most evidence, but instead which evidence you believe. The defendant has been charged with first-degree murder. First-degree murder is a murder in which the perpetrator has the specific intent to kill. To find that defendant guilty of this offense, you must find the following three elements have been proven beyond a reasonable doubt. First, that William Quest is dead. Second, that the defendant killed him. And third, that the defendant did so with the specific intent to kill and with malice. A person has the specific intent to kill if he or she has a fully formed intent to kill and is conscious of his or her own intention. Malice indicates a killing by a person who has the specific intent to kill, provided that it is also without justification. Stated differently, it is a killing with specific intent to kill if it is willful, deliberate, and premeditated. The specific intent to kill, including the premeditation needed for first-degree murder, does not require planning or previous thought or any particular length of time. It can occur quickly. All that is necessary is that there be enough time so that the defendant can and does fully form an intent to kill and is conscious of that intention. When deciding whether the defendant has the specific intent to kill, you should consider all the evidence regarding his words and conduct and the attending circumstances that may show his state of mind. Third-degree murder. Third-degree murder is any killing with malice that is not first or second-degree murder. The defendant has been charged with third-degree murder. To find the defendant guilty of this offense, you must find that the following three elements have been proven beyond a reasonable doubt. First, that William Quest is dead. Second, that the defendant killed him. And third, that the defendant did so with malice. The word malice, as I am using it, has a special legal meaning. It does not mean simply hatred, spite, or ill will. Malice is a shorthand way of referring to a particular mental state that the law regards as being bad enough to make a killing murder. For murder of the third degree, a killing is with malice if the perpetrator acts with a wickedness of disposition, hardness of heart, cruelty, recklessness of consequences, and a mind, regardless of social duty, indicating an unjustified disregard for the probability of death or great bodily harm, and an extreme indifference to the value of human life, a conscious disregard of an unjustified and extremely high risk that his or her actions might cause death or serious bodily harm. On the other hand, a killing is without malice if the perpetrator acts with a lawful justification or under circumstances that reduce the killing to voluntary manslaughter. When deciding whether the defendant acted with malice, you should consider all of the evidence regarding his words, conduct, and the attending circumstances that may show his state of mind. Voluntary manslaughter. The defendant has been charged with voluntary manslaughter. To find the defendant guilty of this offense, you must find the following three elements have been proven beyond a reasonable doubt. First, that William Quest is dead. Second, that the defendant killed him. And third, that the defendant had the intent to kill. If at any time of the killing he believed that the circumstances justified the killing under the principles of justification, but his belief was unreasonable, then he can be found guilty of voluntary manslaughter. Justification. The defendant, John Miller, has raised the issue of whether or not he acted lawfully to protect property, acted in self-defense and in defense of another when he shot William Quest. Such a defense is called justification in the law of Pennsylvania. If the defendant's actions were justified, you cannot find him guilty beyond a reasonable doubt for first-degree murder, third-degree murder, or voluntary manslaughter. The issue having been raised, it is the Commonwealth's burden to prove beyond a reasonable doubt that the defendant did not act in justifiable self-defense. If the Commonwealth proves to you beyond a reasonable doubt that the defendant used deadly force, then to prove that such force was not justifiable in this case, the Commonwealth must prove one of the following elements beyond a reasonable doubt. That while the defendant may claim otherwise, he did not believe that someone had unlawfully entered his dwelling, or that while the defendant may claim otherwise, he did not believe that only deadly force would be adequate to stop the person who unlawfully entered his dwelling. However, even if the Commonwealth proves one of these elements, they still must also prove the following: that the deadly force the defendant used was not needed to prevent the commission of a felony by William Quest in the dwelling. If the Commonwealth proves to you beyond a reasonable doubt that the defendant used deadly force, then to prove that such force was not justifiable in this case, it must prove one of the following elements beyond a reasonable doubt: that the defendant did not reasonably believe that he was in immediate danger of death or serious bodily harm from William Quest at the time he used the force, and that, therefore, his belief that it was necessary for him to use deadly force to protect himself was unreasonable. To put it another way, the Commonwealth must prove either that the defendant did not actually believe that he was in danger of death or serious bodily injury, such that he needed to use deadly force to defend himself at that moment, or that while the defendant actually believed he needed to use such force, his belief was unreasonable in light of all the circumstances known to him. Or that the defendant knew that he could avoid the necessity of using deadly force with complete safety by retreating, but he failed to do so. However, the defendant is not obligated to retreat from his own dwelling, that is, any building or structure, movable or temporary, or a portion thereof, including the doorway, that is at least for the time being the defendant's home or place of lodging, unless he was the initial aggressor of the incident. In various instructions that I have given you on the issue of justification, I have told you that the Commonwealth may seek to prove that the defendant was not justified by proving that he did not reasonably believe something upon which he based his actions. To prove that the defendant did not reasonably believe something, the Commonwealth may prove either A, that the defendant did not actually believe it, or B, while the defendant believed it, his belief was unreasonable in light of the circumstances known to him. It is my responsibility to decide all questions of law. Therefore, you must follow my rulings and instructions on matters of law. I am not, however, the judge of the facts. You, the jurors, are the sole judges of the facts. It is your responsibility as jurors to perform your duties and reach a verdict based on the evidence as it was presented to you during the trial. However, in deciding the facts, you may properly apply common sense and draw upon your everyday practical knowledge of life. Keep your deliberations free of any bias or prejudice. In arriving at a verdict, you should not concern yourself with any possible future consequences of your verdict, including what the penalty might be if you should find that the defendant is guilty. The question of guilt and the question of penalty are decided separately. Upon retiring to deliberate, you should select one of you to be the foreperson. He or she will announce the verdict after you have finished deliberating. Your verdict must be unanimous. Each of you must agree to it. Each of you must decide the case for yourself, but only after there has been an impartial consideration with your fellow jurors. You may re-examine your own views and change your opinion if convinced it is erroneous. However, no juror should surrender an honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. In closing, I would also suggest that you will be able to deliberate more freely and easily in a way that will be better for all concerned if each of you treats your fellow jurors and their views with the same courtesy and respect as you would other persons in your everyday life. So now all the parties are going to leave the room and you're free to deliberate. This is your verdict form. There's only one. The verdict form reads Commonwealth of Pennsylvania versus John Bartholomew Miller, the defendant, in the Court of Common Pleas of Center County, Pennsylvania, Criminal Division, the case number and the charge criminal homicide. The verdict reads, and now, April 12, 2014, we, the jurors impaneled in the above captioned case, find the defendant, John Miller, for each charge that Mr. Miller is charged with. There is one line for guilty and one line for not guilty. At the end is the courtroom, the time that you reach your verdict, and the foreperson's name. So after you've deliberated, just fill one of these out, and we'll end the close. If you have any questions, you can also let us know. Questions for me? Feel free to rearrange yourselves or however you like to deliberate.
I think he's not guilty. I think it's like voluntary manslaughter, like as soon as he went outside the pursuit.
So, well, my reason, when he didn't load, he got his bedroom, so he didn't have any intent to kill at that point, right? So then goes down, and then you just knock on the door. So I mean, the whole argument about, if he didn't go outside, this would never happen. I feel like that was irrelevant, because, I mean,
Need to check out.
if he didn't,
Like say he
if he didn't
didn't
go
pursue
downstairs, it
him.
wouldn't happen.
No, say he didn't pursue him outside, but went upstairs. Everybody came back and just smashed through his window. So I was thinking like he tried to hold him there until the cops came, so that was like necessary.
So then I feel like everything up to there kind of just still
And when he backed into the
doesn't
house,
decide.
I don't think it was attempted kill until after the fourth shot when he chased after him.
Yeah, it's the fifth and sixth shot.
But then remember when they said like he was going to the military to shoot until the threat was dead? Maybe he didn't mean an actual person. That threat was dead could actually mean like until it was stopped, not the actual
Right.
person was dead.
And then so,
Because when he was down on the ground, he
Yeah.
couldn't do anything.
and then when Quest was walking towards him, and then he drive
Triggered
by
the
him.
thing. Yeah, he said he
So-
smiled.
Yeah, he smiled, so he kept walking towards
And
him.
then the thing where he went to the wrong house, I think that was wrong because he went home earlier with a .28. He left back out his house 4:30 in the
Wouldn't it be
morning.
higher because like after time,
It
your
gets
blood
low.
alcohol.
He gets back to normal.
Yeah.
So
He went back at 2:30. The event happened at 4:30.
Yeah.
So he was actually more drunk.
He should be less drunk.
No,
Time
more
away.
drunk when he was.
Oh yeah,
Driving.
I understand. Yeah, he should have been more drunk earlier.
Yes,
So
that's what I'm trying
But
to say.
what really got me was that when he dry fired, Quest still walked towards him. Like he didn't.
Yeah.
When he dry fired, if Quest turned around and walked away, his bullet shots would fall on the back.
Yeah.
But the first two were on the chest after he dry fired. That means Quest was still walking towards him, still being a huge threat. That's what made me think that he's not
And then
guilty.
you think
Truly
about it,
was a threat.
it might not have been. Remember how they were saying it was 1-2 stop, 1-2 stop. It could have been 6 straight.
Yeah.
Think about it.
Yeah, that wasn't even real evidence whether the shells were outside or not. Like that was all speculation.
Because the shells can can travel more once it hits the bottom in the chest. The shells can keep going, and they really didn't have an accurate feet. It could have been 2 feet outside the door.
Yeah, I felt like the main argument with supporting Wes was the fact that bullets were in the back and it seemed like he was walking away. But I feel like that argument is shot down because he still walked towards when he dry fired. So
Yeah, that's my only argument for to be like the strongest for the intent.
yeah, but I think that's an invalid
I mean,
argument.
if somebody coming to my house, I mean, if fifth and sixth shot, maybe. I don't know. He's an elderly man too.
Plus,
Right.
that's a big deal. It's really
Yeah.
terrifying.
He had a heart problem. He can't get any
The
confrontation.
only thing why I think that can like beat the intent part is because he didn't drop after the first 4 shots.
Yeah, why didn't he drop back
at
before
the
shots?
4th, 5th, and 6th? So that will help the defense.
Yeah. So I mean, that's what I kept thinking about. Why did those 5th and 6th shots happen?
He probably, with that adrenaline probably running, prayed
But
and
he didn't
flew.
drop.
Yeah. But I don't know. The only thing I could really picture in my mind, according to the evidence, is the fact that he kept walking towards the face and even after the dry fire. Like the
He
grimace
could have
thing.
walked away when his hands was up. Why didn't he chase him to the house?
Wait,
Yeah.
I don't think he was trying to break in. I think he really had his own house. But then what's weird is like
everything that happened after.
after.
So
He probably was kind of drunk and was just like
Exactly.
thinking he was like Superman. So I don't know.
How come he
Why
didn't
did
use the
he bathroom
bathroom
inside
in
his
the
house? He went outside the house to use the
But he
bathroom.
always goes out to the back of his side.
But that's weird.
Yeah.
Yeah.
You're inside your house.
and then the whole X thing, I thought that was relevant. Did you guys like?
Yeah.
I don't know,
Yeah, that was relevant too.
But you know what?
Just because.
What I don't know could be something too. He could have avoided the defendant could have avoided the situation by not opening the door.
I feel like he
Like,
had
he's
to.
not
He would have.
Kept on going.
Yeah. I
Yeah,
feel like he had
but
every right to see.
Say he
who's
would have
trying
went
to get to his house.
upstairs. The guy could have just came back later. He said it was a thin glass. He could have just really punched through the glass. And went up.
Yeah.
He could have actually got a weapon next time since he said that gun.
And he had every right to see who was trying to break through his
Yeah.
or see,
The guy could have left, got a gun, and came back.
But I think that if he just wanted to stop the person, he could have shot the man on the leg or somewhere to like stop him.
Yeah.
He went after him. He shot him 4 times,
Did he
and
shoot
then
him
he
in
shot
the-
him twice on the back. Sorry.
Did he shoot him in the biceps first?
No, like I think it's like
No, he's
twice here
chest
and
to
then
first.
to
Chest
like,
first?
and then
I just
I
don't
thought
get
he
like
shot
if
him
you
in the
kill, if you
biceps
shoot
first.
twice like this, like how do you get 1 shot here and then 1 shot there?
Maybe it was like,
That's
oh,
fine.
No, think about it. Bam, bam. Body shifting.
yeah.
Did 4 shots from your arm. While your body
So
shifting.
that's like
from
one
left to
thing to think about, like how much space occurred between the 2 shots in the back and the 4 shots in the front, and like I don't know, I think that could have just happened through variance in one case. I don't know.
I mean, really, after 4 shots, what did you think the guy was gonna do to him? He didn't. He wasn't armed. He was probably bleeding or hurt at that time. So why did he add those 2 shots? There was no reason.
They made it
except
seem
he
like the
wanted to
shots
kill
were
him.
breaking up though. You really don't know. It could have been literally 6 straight, like 6 blah blah blah
Exactly.
blah blah.
That's what I think,
Probably
too.
might have emptied the clip. You never know.
But you know they weren't sure because of the last 2.
Look, 2 shots here, right? Body shift, 4 more. He turned it around.
But
He
then-
could have continued the 6 shots.
But that wasn't like, they didn't prove anything. They didn't talk about that. They didn't. Did they say that it was like a straight 6 shot?
No,
So
they tried to
that's
say it was
one
Exactly.
thing.
breaking
Why
up.
So
would-
that's
why
one thing
would-
they don't know at all. So like, meaning that is as possible as it not.
Yeah.
So that's.
Did he say it?
No,
He
nobody
didn't even say it himself.
Yeah,
why
so-
would
I was
like
just
even like why
that's
would
like-
we even like come up with that
So I
that
mean,
idea?
So
That's
wait,
the
remember
thing.
how the opening statement was? The guy tried to say it was 2 shots, ran, 2 more shots, and he pursued them, and he 2
Yeah,
more shots,
I mean,
but nobody.
I feel like that was a
elaborated on
cinematic of
Yeah.
this. I mean,
It-
I feel like that.
To me, it seemed like it would be 6 straight because the way the 4 bullets
Yeah.
were set up. The last 2 shots, you never know what happens.
So that
I
was,
don't think it was 6 straight because there was 4, like almost 4 inside, and then
And then
2
outside.
all the way next to the other house.
Oh.
It couldn't have been 6 right there. Boom, boom, boom.
But the way that he said, that's why they said with the diagram set the scale. It could have been right outside the door. It didn't have to be literally that far as it looked like on the paper. But they didn't know the accurate feet.
Like, it didn't have the scale on how far you chased him.
Remember they said it was not set to scale, as in like the way your eyes is visioning on paper, it really didn't have to be like that.
oh
It
wow, wait a
was set
second.
to scale.
They said it's not set to scale.
Yeah.
So
So,
how
the
accurate is
10
that?
feet could look like 3 feet on paper.
Exactly. Right. So that this whole bullet thing is very unreliable
So don't
evidence.
rely on it.
So that's what I'm saying. The most. So what do we really know? Like for real, for real.
And the guy broke in his house.
Exactly.
Yeah, unloaded gun.
And it seems like the dry fire
It
thing
was loaded just.
No, I'm saying like while he put out his drawer on his safety to go.
Oh,
It wasn't premeditated.
Yeah.
No.
So the only thing it could be is voluntary manslaughter to me if it's not guilty.
Just for
Wait.
it, yeah.
Hold on. So
If it's not guilty, the only thing I think it could be is voluntary manslaughter. I'm on the side of not guilty.
wait. So just real quick, what's the biggest difference between first degree manslaughter?
First degree, he had malice and intent, and then voluntary manslaughter is he just had intent.
Yeah.
Just-
13 minutes max.
And I think he just had intent
They
after
said,
the first
they
4.
said if you got reasonable doubt, which it seems like we all do, we can't charge him with none of them.
No,
That's
we
what-
can't.
Yeah.
We can't.
If we have reasonable doubt, as in like somebody hesitated, we're not allowed to charge him with none of them.
I mean, the whole point is I guess we're
What do you mean? I think if he did hesitate, we can charge him. Because he even, like the defendant even said, like, if he could do it all over again, he probably would have done something different.
But then again, I think that's the case for anyone
I think
that
that
murders
depends on
someone,
anybody, like,
right? Like,
because, like, you never know once you're in a moment.
Like,
Yeah.
he said
Everything
he was,
should happen in a short time period. So I
Yeah.
think it's like
Yeah.
somebody would do everything into.
Then he probably was.
If he was
remember, it
able
was
to
a threat
premeditate.
on him too, with that restraining order thing. He might have thought it was him.
right.
The threat of the ex-husband, remember the
Oh.
threats, whatever.
The only reasons that, I mean, the only reason I didn't think that was a thing was because they said he did see
Yeah.
him before. So, and the lights were on, so I don't know. So,
so then
you know who he is.
he came inside his house and he actually got to see his face
Yeah.
for
Yeah.
a while. So he knew exactly who it was.
and then in the interview, he said,
It wasn't
Yeah.
the ex-husband.
right. So I guess they were just trying to say he was already scared because of this.
You gotta think of your own grandfather when you think about it. And he be that scared, he might have his age.
So, I mean, what do you guys think now? I mean, like, different thoughts.
I just still think about the after the 4 shots, he still had a little bit of intent.
He may not have intended to like kill the man until that exact.
And then how they say she was saying that he didn't go out and check on him. Maybe he wanted to go check on his family. He said, going to go check on a guy I was trying to. He said he could have still been alive. That's what the lady was saying.
Oh, right.
He went up to, he probably put the gun down, went to his family, not went to the guy to make sure he was
He had, I
okay.
don't think he had any legal obligation to really
Yeah.
take after his trigger.
Yeah.
And then the cops were already on the way. Of course, the ambulance is probably coming too.
Right.
I just think the first 4 shots were enough, and then you see him.
Only thing I can think, yeah, I agree with that. Only thing I can think is if it was 6 straight, but that's not clear.
Right. Yeah.
What do you guys think about the last 2 shots? Do you think like it was intentional to kill after he knew the guy was done? Like the guy couldn't do anything else to him?
I don't know. That
And with
picture's
that
like,
double thing, does that mean if you put enough pressure on it, the 2 shots at a time?
that's what I was. That's
No,
what,
no, no,
I
no,
thought
no.
that was the relevance of that, but apparently it's not. It's just
No.
like the pressure goes. I didn't know about that.
Well, actually,
It was just like,
that mean if you do a
It's
double
just-
action,
it's
the
just
shells
pressure.
might go fast up farther.
yeah, it's not like 2 bullets go out, it's just pressure.
Yeah, so
Yeah.
meaning more pressure, the farther shells can go,
Yeah.
which could describe a
Yeah.
really far one. But they never even said which action you used when.
Yeah, because they said the cops never took that down.
Right. But that gun did have that capability.
Yeah. I think there's a lot of missing stuff.
Yeah, there's a lot of missing stuff. But I don't know. So, well, let's. Okay, so
So we know
just-
we did 3 or not guilty. Well, voluntary or not guilty, right?
Yeah.
All right, well, let's try to like focus on the whole, like an aspect at a time. So no intent to kill. So let's think about like his intent to kill.
I think that happened after the 4th shot.
Yeah.
Um,
If it wasn't something. Until
What do you
then,
guys think?
I think he did the right thing, to be honest.
Yeah.
Yeah.
right.
But you put in that circumstance, like somebody's coming at you way bigger than you, like you can't tell like what you're gonna react to in your mind. Like,
Alright, but imagine if it was you drunk and then you got shot 4 times. Okay, you retreat and you turn your back and you like, what if he shot you in the back 2 times? That's not right.
I don't think he.
What would
I really
you
think he
do
was.
if you were confronted by a 300-pound man?
Yeah.
If I shoot him 4 times in the front and I see he's leaving and retreating or like falling
No,
down.
you're like skid out your
But
mind.
then you never know
4:30 in the
how he
morning.
was in the military. You know,
Just
that
woke
changes
up.
your
Yeah.
mindset
True.
when you're in the,
Yeah.
when you're in the military. You're
But,
like
I
somewhere
would
there.
have intent to kill him.
But I mean, one big picture, like, you know, I just keep thinking about the dry fire, because then he only loaded those bullets.
After he shot once, and the guy kept coming.
Yeah.
So it must have been fire once. The guy's smile kept coming, cocked it back.
Yeah. And then he just wanted to eliminate the threat.
Yeah.
So I don't know. That just like kind of trumps the fact that he did 2 more bullets than he should have. In my mind.
My thing is, if he was not he was intoxicated a lot, but he could function properly to get his house the first time. After he went to the bathroom outside, why couldn't he go right back to his door? He goes back to his. He said he goes to the bathroom outside of his house, and there the bushes, not outside of the neighbor's house. So why did he even cross over that way?
I mean, yeah. And another question that crossed my mind, like when he did the dry fire, was it 100% just to threaten him, or was he surprised that a bullet didn't come out? You know what I mean? Like,
I think he
know?
forgot that he didn't.
Right. Okay.
Yeah.
So do you think that he
But-
thought that there was a bullet in there and would have
Yeah.
fired?
And then, but the guy should have
So
went.
then
He
that
should have
would-
left
that
after that.
Well, if that's the case, then that would ruin the whole fact that his whole argument, the fact that he didn't load it because he didn't attempt to kill, right? If he did think it was.
I mean, if it's one shot,
Yeah.
that could just stop it. You don't know where the hell he was aiming at that one shot.
Exactly. Right.
He could have been aiming at the leg first. The guy kept coming. He cocked it back and just shot. It could have been then it hit the chest.
Was he shooting the first 4 or the first 2? Because the first 2 hit the chest. Was he shooting the first 2 so it hit his heart or like just his shoulders? Just
So the first one went into his lungs
And
and
then-
then was bleeding and then.
You really don't know how close the guy was either. He
Yeah.
said as he was backing up, he had the same corresponding steps, so it could have been this far apart.
Yeah. And he also
But
said
I
he was
think at
backed up against
that
the
point
wall.
was self-defense, I guess.
Yeah. So if he was at a filing cabinet, I don't mean it had to be all the way to the back of the building. He had a filing cabinet.
But I think that at that point it was self-defense.
Yeah.
That's just the problem.
I mean, yeah. I feel like the overall tone of it, and the way I saw it was
Yeah.
self-defense.
I think it's like 80-20, to be honest.
Yeah. 8-20 for what? Like what's
So what? Yeah.
Yeah. Self-defense, like 80% doing the right thing, then 2 shots.
Yeah. Is there like a legal action for 80-20?
The
Okay.
80-20 for the 6 bullets, the 6 shots,
Yeah.
or for the 4.
I mean,
I
like
mean,
4 of
like-
them were justified, 2 of them wasn't.
Yeah.
The 4
Like,
of them are justified. Who thinks that the 2 of the last ones are justified? Or is it 80-20?
I mean, like the whole overall thing is like he did the right thing, as in like calling the cops and all that type of thing, leading up to the
Yeah.
last 2 shots were the right thing.
So who believes that the 2 last shots were like?
I feel like
Right.
I, mean,
thing to
I think
do.
you really gotta be fit in that situation.
I feel, yeah, like that picture's not solid enough in my mind. Like, if it all happened within the
I think
same-
I need to actually hear how the gunshots happened.
Yeah.
Like, He could have had one shot. It could be 3 more. It could have been
So
3
for the
shots.
last
then
2
3
shots,
more.
self-defense.
He went to like the military. He knew what, like, I think he had enough experience to know what could like stop a man from coming to hurt him. What would be enough
But-
to get him
but
on
that
the
But he
was-
didn't drop
knew
at the
it.
4 shots.
He didn't what?
He didn't drop at the 4 shots.
He aimed at the heart, and the guy went away. So he knew he was a military man. He should know by the 4th shot that that man wasn't going to do anything. Why?
Yeah,
why
so, like,
he
the
had
That
last
to
was
shoot?
like 40
he had
years
to-
ago.
That what?
That was like 40 years ago.
What?
But I think the
when he was
military
in the
changed it,
service.
like, their minds.
But
But, like,
still,
the-
do you forget it? Like, I mean, like
The
if
last
it-
2 shots,
that's
I
something
think,
like
do you guys think it was self-defense? The
I
guy
can
wasn't
accept
coming.
the first one, but not the
For the,
two last
for the last 2, I'm sorry. For the last 2 shots, do you guys think it was self-defense? Because the guy wasn't coming towards him anymore. Do you guys think it was self-defense?
I really think you got been in a situation. So,
I don't think it was premeditated at
yeah,
all.
definitely.
No, I don't think it was premeditated. The last 2 shots was he protecting himself at that point?
No. My head actually thought, yeah.
He wasn't. He wasn't. The guy wasn't coming towards him anymore. So why they weren't necessary? They weren't necessary for self-defense. They weren't intentional. He.
You think if somebody's coming at you, what if it was a 6-shooter? 6 rounds in the clip. You just really just emptied the gun.
Yeah, that would definitely help his case.
Because if you shooting, say he did shoot 6 times straight, you shoot 4 times, hit him in his chest, he's turning around, you still continue shooting while he's turning. Because it said hit him like it showed on a downward motion. It didn't say he was already on the ground. The 5th shot was on a downward motion. The 6th shot was actually on the ground. So he probably just kept shooting.
6 shots already at the ground.
The 6th shot was on the ground. The 5th shot was on the way to the ground. So he most likely was falling, turning around. Because they didn't say, they said the 6th shot was on the ground, the 5th shot was on a downward motion.
Alright,
So the only thing I'm thinking in my head is he literally emptied the 6th shot.
Yeah, I might be leaning towards military manslaughter now.
What you think?
Voluntary manslaughter with the 5th and the 6th shot.
Yeah. I think it's a long-term lifestyle. Yeah, it's not great.
Because of the 5th and 6th shots. He wasn't acting in self-defense at that point.
That's what we're going. Sure. Everybody? Listen,
time.
Who's the 4th person?
The what?
4th person? Who wants to speak?
The 12th.
You don't say data?
Oh, I thought I said it.
Courtroom? Guess that doesn't matter.
Like 5 days before.
Judge. What's the judge name?
Don't worry about it.
We're done.
Counsel for the Commonwealth is present, as well as Mr. Miller and his attorneys. Ladies and gentlemen of the jury, have you reached a verdict?
Yes.
Okay, and are you the 4th person? Okay, please render the verdict.
On the count of first-degree murder, we chose not guilty. On the count of third-degree murder, we chose not guilty. On the count of voluntary manslaughter, we chose guilty. On the count of possession of a firearm, other weapon with intent to employ it criminally is not guilty.
Okay, thank you.